arraignment, so let me make sure we're on the record here. And we can see you, you can hear us.
Yes.
Okay, very good. We're ready then to call the first case, counsel.
Thank you, Your Honor. This is Merkel and Terry Schroyer with Special Prosecutors on behalf of the state of Ohio. This is case number 23 CR 3820, which is a two-count indictment, count one charging murder, and count two charging reckless homicide against Ricky Ray Anderson.
Good afternoon, Your Honor. May it please the court. Caitlin Stevens, 0095589, here on behalf of Mr. Anderson. Your Honor, my partner, Mr. Collins, apologizes that he could not be here for today's arraignment. However, he is handling a different matter outside of the state. Your Honor, we enter a not guilty plea, waive reading of the indictment, accept service of the indictment, and acknowledge an arrest date of August 4th, 2023. I'll speak to bond, Your Honor, as the court, when the court deems it appropriate.
All right, thank you. Do you wish to address bond first? Hear from whoever wishes to speak first.
Thank you very much, Your Honor. I'm sure this court has read our bond motion that we filed on behalf of Mr. Anderson. And as this court is aware, pursuant to the Ohio Revised Code 2937.011, the court shall release the defendant on the least restrictive conditions that 1, assure the defendant's appearance in court, 2, assure that he is not a danger to the community, and 3, assure that he will not obstruct the criminal justice process. Your Honor, when we look at the factors delineated in 2937.011, we submit these factors favor a reasonable bond not to exceed $250,000. Concerning his appearance in court, Your Honor, my client is 60 years old. He's got no prior record whatsoever. He has no history of habeas, warrants, or order ins. When he did find out, Your Honor, that there was in fact a warrant for his arrest, he voluntarily surrendered himself to the Franklin County Jail. Your Honor, this incident occurred 11 months ago. During those 11 months, my client has complied with this investigation. He provided a written statement. He allowed his passport to expire. For 11 months, Your Honor, he remained in this jurisdiction, awaiting the presentment of his case to the grand jury. He knew that this case was going to be presented. He knew he was still under investigation, and yet he still remained in Franklin County. As such, Your Honor, we submit that he is not a flagrant, and this factor favors a reasonable bond. Concerning the safety of the community, Your Honor, in addition to the fact that my client has no record whatsoever, he has removed all of the firearms out of his home and no longer possesses them. He has retired from law enforcement. He has complied with mental health treatment requirements mandated by the Division of Police. On August 30th, 2022, Your Honor, he lawfully carried and was required to carry a gun when he had to face every police officer's nightmare and make a split-second decision on defensive justification that this court is well aware is afforded to him by the Supreme Court of the United States. If the special prosecutors believe that Mr. Anderson was in fact a danger to the community, Your Honor, logic dictates that they would have rushed this process to the grand jury. However, they allowed him to remain in the community for 11 months. We submit, Your Honor, that the governmental inaction for those 11 months dictates that he is not in fact a danger to the community. And as such, Your Honor, this factor favors a reasonable bond. Concerning the third factor delineated in the Ohio Revised Code, Your Honor, whether Mr. Anderson will obstruct the criminal justice process. Your Honor, he was a police officer for 31 years. He voluntarily complied with all aspects of the investigation. There's no evidence whatsoever to support that my client will in fact obstruct the criminal justice process. And in fact, the evidence before this court in terms of compliance and in terms of lack of record dictate the opposite, that he will not obstruct the criminal justice process. Finally, Your Honor, every day, this court works tirelessly to avoid the disparate treatment of similarly situated defendants. When analyzing bail, Your Honor, the need to avoid disparate treatment is key to both due process and equal protection. Mr. Collins and I have represented 2 law enforcement officers under nearly identical situations. They're both cited in my motion, which I provided to the court. One was given a $250,000 bond, and the other was given a $100,000 bond. And so when you analyze the factors, Your Honor, set forth in 2937.011, coupled with the viable defensive justification and the need to avoid disparate treatment of similarly situated defendants, we submit, Your Honor, that Mr. Anderson should be granted a reasonable bond not to exceed $250,000. Thank you, Your Honor.
Clear the record.
Yes, Your Honor. First of all, we got a copy of the motion. There's just two things. One first one. Page 5, when he said, Mr. Anderson was voluntarily complied with law enforcement at the scene and answered questions with respect to that transpired. He did not. There were no statements taken at the scene. And didn't answer any questions. Also, on page 8, where in their motion referencing that he continues to cooperate with this investigation. I'm not sure whose investigation they're talking about. Maybe he's cooperating with the defense's investigation, but that doesn't apply to us. That he was asked by DCI and offered, and was given an opportunity to sit down and be interviewed, and he did not. So I just wanted to clarify a few things in their motion. With respect to bail, we're asking the court to set commensurate to the charges of bail. That being taking the life of another, being murder, reckless homicide, and something that's not demeaning to the loss that this family has suffered. Serious charges of this nature inherently create, with all defendants, a risk of non-appearance. The grand jury, after a grand jury indictment, more so than before. So, Your Honor, we would respectfully ask the court that we believe that a certainly is appropriate for the court to set a substantial bail, either surety, cash, or appearance, some type of financial bail must be met, along with any other restrictions that the court feels would be necessary. Passport. I know they said that this passport is expired. Perhaps in order that its passport's got obviously weapons. There be no weapons. And any other restrictions that this court deemed would be appropriate to make sure that that he does appear for all court proceedings.
Apart from the monetary part of his bond, you've mentioned no weapons and you've mentioned turning the passport. Are there any other conditions that we typically put on bonds that you're looking for? For example, are you looking for a no contact with any of the witnesses or anything of that nature?
I don't know if that's necessary, but if the court feels that that would be appropriate in this case, that would be fine.
So you're not specifically requesting that. Anything further from?
Your Honor, just that Mr. Anderson absolutely submitted a written statement to the BCI agent, and he did in fact comply with that request.
I might add, that written statement was over a month later. Okay.
After the incident?
Yes, not at the scene.
You indicated that the officer state you didn't have an objection to the clearance concept.
Your Honor, whatever the court says is on this. Under these circumstances.
The defendant has entered a plea of not guilty. The bond is going to be a $500,000 surety or appearance bond, $20,000 recognizance bond, and there are going to be two conditions placed upon the defendant's bond. First of all, he is not possessed or use a firearm of any kind, and also he is, I understand the representations been made that the passport has expired, but I am making any condition of bond with the surrender of the passport. Thank you all very much.
Thank you, Your Honor.
you want to say anything, Phil?